This is file 24-51516-DS, Tesla and Young versus Alexander Lee Dominique. We are here today for arraignment on a bench warrant in this case, and we are proceeding today by video conference. So you are Alexander Lee Dominique?
Yes, sir.
Mr. Dominique, you are being arraigned on a bench warrant. The bench warrant alleges that you failed to appear in court for a hearing on a front of the court show cause on December 2, 2024. The underlying front of the court show cause alleges that you have a monthly child support charge of $279, and there is currently an arrearage in payment of your child support in the amount of $3,966. Do you understand that those are the allegations against you, Mr. Dominique?
Yes, sir. I'm literally
okay. Before you say anything else, I need to ask you a few questions so that you understand what your rights are. All right. So,
yes, sir.
Do you understand that it is a crime to fail to pay child support to the best of your ability up to the amount ordered?
Yes, sir.
Do you understand that it's also a crime to fail to appear in court when you've been ordered to appear?
Yes, sir.
Do you understand that if you were to plead guilty or be found guilty of either of those offenses, that the court could sentence you to jail for a period of up to 30 days?
Yes, sir.
You are entitled to have a trial, and you can't be convicted unless the evidence at your trial proves that you're guilty beyond a reasonable doubt. Do you understand that?
I don't understand that, but yeah, I guess it makes, yeah, go ahead.
Okay, so you can have a trial at which time you would present evidence, the front of the court would present evidence, and I would make a determination as to whether you were guilty or not guilty. And you would have to be proven guilty. If you're going to be found guilty, you would have to be proven guilty beyond a reasonable doubt.
Okay.
You're entitled to have an attorney represent you here today and at any other proceedings that we might have on this matter. If you can't afford your own attorney, I will appoint one for you from the public defender's office. Do you understand that?
Yes, sir.
Do you want to be represented by an attorney?
Yeah, please.
Do you have the ability to pay for your own attorney?
No, not right now.
All right, I'm going to put you in a breakout session with Ms. Underwood from the public defender's office. If you give me just a moment.
All right, thank you.
Ms. Dumont, I believe we have Ms. Burciaga here. Do you need to speak to her?
No, Your Honor. She retained counsel, and I signed a substitution.
Oh, I'm sorry. Do you know who that is?
Mr. Brandt.
Okay. Good morning, Mr. Brandt. You are here for Ms. Burciaga, is that correct?
That is correct, Your Honor.
Okay. She is logged in. Do you need to speak to her before going on the record?
No, Your Honor. I have one question, though. I have the substitution of attorney. I will bring that down for the court's signature this morning. I did not get down there before today.
Okay.
I did speak to my client, and I talked to the prosecuting attorney. I believe the co-defendant has a pretrial April 30. I think what we'd like to do is do both of them April 30.
Okay, is that accurate, Ms. Arnold?
It is, Your Honor.
Okay, so we'll adjourn it then to April 30th at 8:15 a.m.
Thank you, Your Honor.
Mr. Brandt, would you also be willing to do a stipulation in order for that adjournment?
I will bring that down this morning as well, Your Honor.
Sounds good. Is there anything else we need to address with this case today?
Judge, I believe Mr. Brandt is looking for some discovery that was too big to email. If he brings some sort of flash drive thingy, we can try to download that for him while he's here.
I will bring a thingy with me.
All right, thank you.
Okay. All right, then, Ms. Bursiaga, your next date will be April 30th at 8:15 a.m. and you can log in using all the same Zoom information that you used today.
Okay, thank you. I'm fine to leave now.
Yeah, I'm sorry. You can go ahead and log out.
Thank
Thank
you.
you, Your Honor.
Thank you. Okay, back on the record in Young versus Dominique. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Dominique this morning, Your Honor. Thank you. Mr.
Yeah.
Dominique, Your Honor, is waiting to hear back from K&B Asphalt. He's interviewed with them for a job, and that looks like that's probably where he's going to be working. Mr. Dominique can make a $100 payment by Friday, Your Honor. We would very much appreciate a PR bond in this matter, a not guilty plea, and a $200 payment by Friday, or a $100 payment by Friday. And Mr. Dominique should hear from K&B this afternoon, Your Honor. So that's pretty important. And then just a short adjournment to assure the court that all that has taken place.
All right, so I will grant a PR bond conditioned upon a $100 payment to be made by Friday. I will also indicate at this point that the friend of the court notes are that Mr. Dominique has made 0 child support payments since the inception of this case, and obviously we've got the failure to appear issue. So Mr. Dominique, this is your one chance to get it right.
Okay.
So if you don't appear again, if you continue as you have been, just not making any payments, you're going to find yourself in the same situation, and I'm not going to be inclined to talk about bond then at that point. It's time to do the right thing.
You're right.
All right, so you are all set for today. I'm sorry, so we need another.
Your Honor, what is that date again?
I'm sorry, so. I'll adjourn this to April 28th at 8:15. So, Mr. Dominique, you need to be here in court on that date at that time, or logged into the Zoom session, and they have our Zoom information, I believe, at the jail for you.
You said 28?
Correct.
All right, thank you, sir. Are we done?
Yeah, you can let them know that you.
Thank you, Ms. Underwood.
Good luck, Mr. Dominique.
Thank you. I'm locked in here. I can't get out.
Tyndall.
Could we have Joseph Ballard in the room? Oh, yeah, Judge Olsey first. Could we have Joseph Ballard? Okay, in another room, could we have Terrence Tyndall?
Hey, Judge,
Okay, thank you so much.
Yeah,
Bye-bye.
I'm your arraignment agent, just so you know.
I'm sorry.
I said I'm doing arraignments, just so you know.
Oh, okay.
Oh, like an hour late sometimes. She's done it when I went to court before.
All right, I have someone here logged in from an NDOC facility. Are you Mr. Hall?
Yeah. Yeah.
Okay, Ms. Underwood, do you need to speak to Mr. Hall?
Oh, no, I don't believe so, Your Honor.
All right, 1 second. This is file 24-21859-FH People versus Heath Michael Hall. We are here today for a pretrial conference in this case and proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayanetto?
Alex Bayanetto for the people.
Rhonda Underwood for Mr. Hall this morning, Your Honor. Thank you. I believe this is the date and time scheduled for a competency update on Mr. Hall, Your Honor. The competency update we have received, Your Honor, is that Mr. Hall remains incompetent, but is restorable. We have no objection to the court using that update and providing and continuing the orders based on that, Your Honor.
I shoot for dismissal on the ground. It's bullshit. I didn't even do nothing.
Mr. Bayanetto?
Your Honor, I'd ask that the court accept the report into evidence, and I would ask for another review date, maybe in about 90 days, so we can see where we're at.
I have received and reviewed that report. I do think it's appropriate to accept that into evidence and set this matter out for a period of another approximately 90 days to determine what the status of Mr. Hall's competency is at that time. So 90 days from today, in about the middle of July, we can set this for July 16th at 8:15 a.m.
July 8th, Your Honor?
July 16th.
Okay.
Is that all?
That's
All
all,
right, so
Mr.
that will be all for today, Mr. Hall. You can let the officer with you know that you're done with court for today.
Thank you. I'm not.
Okay, Ms. Dumont, do you need to speak to Mr. Tyndall?
No, Your Honor, we're ready.
Oh,
Yeah.
that's sure.
I'm sorry?
Let's speak to her real quick.
Yeah, 1 second. Ms. Underwood, do you need to speak to Mr. Ballard?
I don't believe so, Your Honor.
Okay, so this is file 24-21953-FH People versus Joseph Wallace Ballard. We are here today for a hearing on a probation violation, and we're proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Your Honor, Rhonda Underwood for Mr. Ballard.
All right, and where do we stand with Mr. Ballard's case today?
Your Honor, Mr. Ballard has a case that was down in district court, and I believe it's coming up to circuit court in short order on a pretrial. So, but I don't think a date's been given yet. So we would ask that this be set with that, Your Honor.
Do you know what his next date in district court is then?
I'm sorry?
Do you know what his next date in district court is?
Well, it's not in district court. It's on its way up here. I believe it was scheduled for arraignment next week, but we waived arraignment for a pretrial, Your Honor.
It does say bound over, but I don't see anything in the circuit court records of it yet.
Yeah, they don't appear to have a file set up for it.
Yeah.
Okay. All right, let's set it for April 30th, and when that circuit court gets file gets set up, we'll try to set the other one for the same date as well.
Thank you, Your Honor.
Okay, Mr. Ballard, you can let the officer with you know that you are done with court for today.
Yes, Your Honor. Thank you.
Okay, Ms. Dumont, are you ready to proceed with Mr. Tin?
Yes, Your Honor.
Okay, this is file 25-22149-FH, People versus Terrence Jerome Tyndall. We are here today for a pretrial hearing as well as a hearing on alleged bond violations, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonet?
Alex Bayoneto for the people.
Katerina Dumont for Mr. Tyndall.
And Ms. Dumont, where do we stand with Mr. Tyndall's case today?
Your Honor, we are getting him screened for drug court. We have an offer on the table in which, if drug court is completed, this case is dismissed. Mr. Tyndall also has a new charge that's set for a PCC on Friday in Judge Shadler's that we will try to, we have the same offer, essentially a global resolution, where if he completes drug court, that is to be dismissed as well. The only thing at this time he's concerned about is his bond. He wants the court to issue him a PR bond. I advised that I don't believe the court is going to do that based on the previous bond violation. However, if we could get his bond changed so he could be released on a PR to an inpatient treatment facility is what we would be asking, along with an adjournment to get the other felony case upstairs and see if he's eligible for drug court.
Okay, Mr. Bayoneto.
Your Honor, I did just send Ms. Dumont a text message regarding the offer. The file that I'm looking at shows that the offer was revoked on 4/9. So I think Ms. Dumont might want to touch base with Mr. Sneed about that. I still think screening for drug court might be a wise decision in this case. So I think that would be appropriate to set this for another pretrial to see if he does qualify for drug court. I would object to a PR bond even with a release to inpatient at this time. Mr. Tyndall has shown time and time again he is struggling with his addiction. I think if he's going to get himself into drug court, I think perhaps release at that time would be more appropriate. So I would ask that the court not modify bond at this time, and then perhaps we can readdress that issue when we come back next time.
All right, Mr. Coast, is there anything you wanted to add about the bond issue?
Yeah, Judge, the only problem with being released to an inpatient, I mean, thus far he's denied all use. I mean, we've had 3 positive meth screens, and he's still denying using. So for us to even consider being released to inpatient, I mean, he's going to have to admit to his use, admit that he has a problem.
And Your Honor,
Yeah, go ahead.
the issue is, while he's incarcerated, he's not getting any services with regards to substance abuse issues or any kind of treatment. And I know the screening process does take a bit, and he has been incarcerated now for quite a bit. So he is clean and sober.
Okay, well, he was arrested, according to the file, on April 7th for the latest warrant. That, in the context of what his substance use situation seems to be, is not a very long time. I do think I would like to know the results of the drug court screening before agreeing to release him to an inpatient facility. I don't have, I'm generally willing to do that. However, in this case, I'd like it to be in the context of we're moving forward toward drug court, and we know what's going to happen. So I'm perfectly willing to revisit that decision once we know what the drug court screening situation is going to be, and once we know, if he's going to do this as part of an agreement, that we know what that agreement is. But at this point, I'm just not comfortable on a release on a PR bond to to anywhere right now, because it does appear that Mr. Tyndall has a pretty serious substance use issue, and this is the best way I have to make sure that does not continue for the time being. So I'm going to deny the request to modify bond at this point. As I said, again, I'm willing to look at that again if we know with better certainty how this case is going to go. I apologize, Ms. DeMont, you said his probable cause conference on the other file is when?
Friday.
So I can adjourn this to April 30th. So 2 weeks from today, and perhaps at that time we'll have better understanding where things are going to be headed.
Thank you.
Thank you, Judge.
Ms. DeMont, would you be willing to do a stipulation in order for that adjournment?
Yes, Your Honor.
Okay. Thank you. All right, Mr. Tyndall, you can let the officer with you know that you are done with court for today. And April 30th.
Mr. Sepulveda is not in our jail.
The gentleman at the MDOC facility, can you tell me your name, please?
Jason Evans.
I'm sorry, your microphone was bad. I had a hard time hearing you, sir. Can you tell me your name again?
Jason Evans.
Okay. Ms. Underwood, you need to speak to Mr. Evans.
Yes, Your Honor. Thank you.
I know that's what they said too, but they said it has more to it. H99, which means he's out somewhere else.
Okay, Ms. Galguera, you are here for Mr. Hoover, is that correct?
Yes, Your Honor.
Okay, Mr. Hoover is here. If you give me just a second. Okay, this is file 24-22039-FH, People of the State of Michigan versus Ryan Patrick Hoover. We are here today for a pretrial conference. In this case, we are proceeding today by video conference. First, can you have the attorneys place their appearance on the record, beginning with Ms. Arnold?
Allison Arnold for the people.
Good morning, Your Honor. Fabiola Galguera on behalf of Mr. Hoover, who's present via Zoom.
All right, and where do we stand with Mr. Hoover's case today?
Judge, Ms. Galguera has sent me some information regarding the case. We are looking into it, but I think it would be best to set trial dates today, just to reserve those dates, given the victim's schedule and the court schedule, and wanting to accomplish a trial prior to the fall, when one of the victims would be going back to school. So if we can set those trial dates today, I think that would be appropriate. And if we resolve the case, we'd certainly let the court know.
Okay, Ms. Gallagher, is that agreeable with the defense?
Yes, Your Honor.
And how many days, Ms. Arnold, do you believe we'll need for a trial?
Judge, I think We probably could do it in 2 days, but I think we better set it for 3 just to be safe. And just so the
Okay.
court knows, I do expect a plea in the Matthew Higgins case today, which would free up June 24th to June 27th on the court's calendar.
Okay, Ms. Galgare, do you agree that 3 days is a sufficient amount of time?
Yes, Your Honor.
Okay. And Ms. Clark, are we able to put that in for June 24th to the 27th in place of the Higgins case? I think Ms. Clark may be on the phone. I had just sent her a chat message asking her to track someone down for me, so.
No worries.
Why don't we plan on that? So June 24th through the 27th. Ms. Galgare, if that works with your calendar.
I just checked my calendar. It does work, Your Honor.
Okay. And if something happens with that date, we'll get in touch with you and let you know we'll need to arrange some other dates. But otherwise, the court will issue a scheduling order with those dates in it and send a copy to everyone.
Thank you, Your Honor.
Thanks, Judge.
Oh, I'm sorry. We'll need a final pretrial as well. So let's go with. Go with June 18th at 8:15 a.m. if that date and time works.
It does, Your Honor.
That should be fine, Judge.
Okay. All right. Is there anything else we need to address with this case today?
No, thank you, Judge.
Not for defense, Your Honor.
All right. We're all set then, Mr. Hoover. You can go ahead and log out.
Thank you, Your Honor.
Okay, Mr. Grable, you're here first. Sepulveda and Flores, is that Emily Flores?
I believe that's correct, Your Honor. I'm filling in for Mr. Amadeo. He gives you his apologies. He's homesick with the flu on both those matters. But I'm here.
Ms. Flores, you- So Ms. Flores has a couple of cases. Do you just represent her on one of them? I thought Mr. Fry represented her as well.
My understanding, Your Honor, is Mr. Amadeo was replacing Mr. Castleberry on that particular file where Mr. Castleberry was the attorney of record. That's what Mr. Amadeo conveyed to me. I hope that clarifies.
Yeah. Blessing I haven't filed was the Frank Fry. Has Mr. Amadeo filed a substitution of attorney, or because I have in both files that Mr. Fry was appointed as special public defender for her.
I don't believe he has, Your Honor, and I apologize. I did not ask him that question. So I'm not sure, but I don't believe he has, Your Honor. Obviously, that's why it's not in the file. For some reason, Mr. Amadeo indicated to me that he thought Mr. Castleberry was the attorney on Ms. Flores's matter.
His name would be on the doc. He's the person that assigns special public defenders. But
Okay,
that's not.
Okay, well, I apologize for that. Well, I don't know where the paperwork is on that, Your Honor. I apologize. My understanding is Mr. Castleberry asked Mr. Amadeo to take over the file, or perhaps the files, plural. And I apologize for the confusion, Your Honor. And I can make sure Mr. Amadeo is aware of that, so that paperwork can be filed forthwith, Your Honor.
Well, the problem is you're telling me you're substituting in, but I don't have anything from the attorney of record that says that, which I would need in order to proceed. So I think we're going to have to wait until Mr. Fry is here.
I understand, Your Honor. And also, I guess I'll just mention, Mr. Amadeo, for what it's worth, has reached out to Ms. Flores. She, for whatever reason, he didn't get a reply. I guess we could deal with that when Mr. Fry gets here, and I'll let the court proceed and not delay the rest of the docket. I apologize.
Okay. All right. So Ms. Flores, you can, I guess, if you want to take a step back to where you were, you can go back there for a while, and as soon as they'll bring you back up. This is file 25-22174-FH, People versus Jason Allen Lee Evans. We are here today for a pretrial hearing in this case and proceeding today by video conference. First, can I have the attorneys place their appearance on the record, beginning with Mr. Bayonetto.
Alex Bayonetto for the people.
I'll now do it for Mr. Evans this morning, Your Honor.
All right, where do we stand with Mr. Evans' case?
Your Honor, this is our first pretrial. I do have some information that I would like to check out. I think this will probably result in a plea, Your Honor, but I think there's something I need to check out before another pretrial. So I would request another pretrial in the not too distant future, Your Honor.
Okay, Mr. Bayonetto, anything to address from the people's side?
No, Your Honor. We have no objection to an adjournment.
And I would be happy to do the stipend order on that, Your Honor, with Mr. Bayonetto's permission.
All right, then let's go with May 14th at 8:15 a.m.
Thank you, Your Honor. Can you repeat that date again?
May 14th.
Oh, thank you.
Your Honor, I reached out to Mr. Fry about the Ms. Flores case, and I don't know why I didn't think of this when we were discussing this on record. The new 25 file, Ms. Flores's son was charged out of the same incident. He is still a minor, and Mr. Fry represents him. So he had a conflict in this case, and I think that might be where the confusion came in and why Mr. Amadeo is taking things over.
Okay.
Actually, I think Ms. Flores' son was may have been charged in both cases.
All right. Okay, Ms. Flores, you want to come back forward and you can sit at the table closer to the television. All right, then, so this is file 25-22118-FH and 24-21886-FH, People versus Emily Kristen Flores. We are here today for pretrial conferences in both of those cases. First, I have the attorneys place their appearance on the record, beginning with Mr. Van Netto.
Alex Bayanetto for the people.
Good morning, Your Honor. Attorney Scott Grable, P53-310, appearing on behalf of Ms. Flores. Replacement for Mr. Amadeo was homesick with the flu, Your Honor, as I mentioned earlier.
All right, and so where do we stand with Ms. Flores's cases today, Mr. Grable?
Your Honor, my understanding is Mr. Amadeo communicated to me he has reached out to Ms. Flores. For whatever reason, he did not get a reply from her. I'm not sure. You would have to ask her at least if she got the message or didn't. We would ask the court for a short adjournment and, ask Ms. Flores at her earliest convenience to contact Mr. Amadeo, and I can provide her that number or my number so she can reach out to him at her earliest convenience.
Okay, why don't we do this? We will set an adjourned date, and then Ms. Flores, when we're finished, I'll have you step outside. There's an iPad right outside the door, and if you log in on that, I'll put you in a breakout session with Mr. Grable so that you can
Thank you, Your Honor. Thank you, Your Honor. I appreciate that courtesy.
No problem. So let's go with May 14th at 8:15 a.m.
Thank you, Your Honor.
And Judge, we also have the contempt where she registered numbers. But since that positive, she has done much better. No additional positives.
All right, Mr. Grable, would you be willing to do a stipulation in order for that adjournment?
I would, Your Honor. Thank you.
Okay. All right, so Ms. Flores, then if you want to step right outside the door to the iPad and log in on that, I'll put you in a breakout session with Mr. Grable.
They haven't appeared yet.
I don't know. Yeah, he's
He's supposed to appear in person. That's his video.
this is file 20-19849-FH and 20-19796-8FH. People of the State of Michigan versus Anthony Harris Moore. We are here today for a hearing on, got a pending bench warrant for Mr. Moore related to a failure to appear at a probation violation hearing and the underlying show cause for a probation violation summons. Sir, you are Anthony Harris Moore?
Yes, Your Honor.
Mr. Moore, this is a court proceeding, and I know you're attending by Zoom, but we treat that as though you were here in person, so I'm going to ask you to take your cap off.
Oh, I'm sorry.
Mr. Moore, have you received a copy of the request and summons for probation violation?
No, I haven't.
All right. I will let you know that there's a summons for probation violation in each of the files. Both of them allege the same thing, that you have failed to pay your court costs as ordered. In file 19796-FH, the allegation is that you still owe $1,003. In file 19849-FH, the allegation is that you owe $198. In that file, you had pled guilty to possession of methamphetamine. The maximum possible penalty for that offense is up to 10 years in prison. In the 19796 file, you had also pled guilty to possession of methamphetamine, and the maximum possible penalty for that offense is the same thing, up to 10 years in prison. There's also a bench warrant pending for an alleged failure to appear at a hearing on the summons for probation violation on March 12, 2025 at 8:15 a.m. Do you understand, sir, that those are the allegations against you?
Yes, I do.
I've told you the maximum possible penalty for the probation violations, the maximum possible penalty for a contempt of court, which is what the failure to appear would be, is up to 93 days in jail. Do you understand that?
Yes, I do, Your Honor.
You are entitled to be represented by an attorney here today and at any other proceedings that we have regarding this matter. If you can't afford your own attorney, you can tell me that and I'll appoint one for you at public expense. Do you understand that?
Yes, Your Honor.
Would you like to be represented by an attorney today?
Yeah, why not? Yeah.
Do you have the ability to pay for your own attorney?
No, I do not.
All right, I'm going to put you in a breakout session with Ms. Underwood from the Public Defender's Office, if you'll give me just a moment.
Your Honor, what is the last name on this?
Moore, M-O-O-R-E.
I don't believe I've received anything on this yet. Hang on, unless it's just been sent.
Francis
He just requested you.
Okay, can you call for Mr. Higgins? Ms. Hoffman, we're just waiting on Washtenaw County to get logged in. Mr. Sepulveda, so as soon as we have him, we'll get started on your case.
We can't maybe present it forward.
No, they're not logged in yet. I don't know what it's going to be, unfortunately. Okay, I think do Dill. Yeah, Dill. Okay, Mr. Burkett, Mr. Dill, I think we're ready to call Mr. Dill's case.
Yes, Your Honor.
This is file 24-21967-FH, People versus Deontay Laquan Dill. We're here today for a pretrial conference in this case, and we are proceeding today by video conference. First, can I have the attorneys place their appearances on the record, beginning with Mr. Bayonetto?
Alex Bayonetto for the people.
And good morning, Your Honor. Raymond Burkett on behalf of Dill.
All right, we did have a conversation off the record about Mr. Dill's case earlier in the week. So Mr. Burkett, how do you want to proceed from here?
Well, Your Honor, as I said in our meeting, you had already made a ruling, and it's my understanding that, and we agree with the ruling you made. If the prosecutor didn't like the ruling, their option was to appeal it. They have not appealed your ruling to the Court of Appeals, and as far as I'm concerned, I believe your ruling should stay in place. And basically, that's what I'm asking for. Since you already know the background and we went through it thoroughly Monday.
All right, Mr. Bayonetto.
Your Honor, I'm looking at the file. I don't see that Mr. Sneed added any notes about Monday's meeting, so I can't speak to anything that happened there. And I would just ask that I would just leave it in the court's discretion as to how to proceed at this point.
All right, so the court's ruling on the prior motion to quash the bind over was that there was a further factual record that needed to be developed in order to determine whether the bind over was appropriate or not. It was sent back down to the district court, and then a waiver was filed of the preliminary exam to bring that back upstairs. So I don't think that the ruling that I previously made would require me to dismiss this case because it was again that there was a further factual record that could be developed in a further proceedings on preliminary examination, and then that preliminary examination was waived. So at this point, I am not inclined to, if the request is that I dismiss it based on what my ruling was on the original motion to quash, I'm not inclined to do that. I don't think that's appropriate under these circumstances. And if there's a further motion that needs to be filed to continue to address that issue, then so be it. But based on how I have ruled previously and the waiver of the continued preliminary examination, I don't think that that would be appropriate. So I can set this for another pretrial, Mr. Burkett, and if you feel there's an appropriate motion for you to file, we can address that. But I wouldn't be taking any action in that regard today.
I respect that, Your Honor. And just so the record is 100% clear, Um, I understand exactly what you're saying, but I want the record to be clear. Our position is we don't need another pretrial, but we would do that if the court just will allow me enough time to retrieve the transcript that we had with you. I'd be happy. I would like to do that, and then I would like to have the pretrial that this court has suggested. I hope I kind of made myself clear here because I'm stumbling around here with my argument.
That's okay. So I understand you to be asking for another pretrial, but at a time after you can get the transcript of the hearing on your motion that we had.
Yes, sir. And with all due respect, Your Honor, I'm saying that based on your ruling before, the case should be dismissed. But I understand your position, but just to protect the record.
Okay, I understand that. So am I correct, Mr. Burkett, that you still need to order that transcript of that hearing? Is that right?
That is correct, Your Honor.
Okay, I'm just trying to get a sense of how far out to look. So we're going to be looking, as a practical matter, probably at the first part of July while we wait for that to get prepared.
Okay.
How about July 16th at 8:15 a.m.?
Okay, I'm almost positive that's okay. Just give me one brief second. July 16th. Okay. Now, Your Honor, that'll be fine. One quick question though, Your Honor. Would that be by Zoom or would it be in person?
Yes, that will be Zoom.
Okay. July 16th would be fine, Your Honor.
All right, so I think we're all set with this case today. Then if there's nothing else, you can go ahead and log out.
Okay, Your Honor, hope you and your staff have a nice day today. And thank you very much for your concern.
Thank you. Hold jail for Mr. White. Okay, Mr. Mawad. We've lost Mr. Mawad.
Can we have John on default, please? Thank you. Bye.
We are back on the record in file 20-19796-FH and 20-19849-FH, People versus Anthony Harris Moore. Ms. Underwood, would you like to place your appearance on the record?
Bond Underwood for Mr. Moore this morning, Your Honor. Thank you.
And do you know how Mr. Moore would like to proceed?
Yes, Your Honor. I believe we would like to continue a not guilty plea in this matter and set this out for an adjournment, Your Honor, to allow Mr. Moore to continue to make payments in this. I know he made a payment yesterday and it looks like he's making some strides. So we would appreciate a brief adjournment.
All right, I will enter not guilty pleas for Mr. Moore then on all matters. And set this for a hearing on May 14th at 8:15.
That'd be a hearing or a pretrial?
A pretrial.
Thank you.
Ms. Holly,
Yes.
do you have all Mr. Moore's updated information?
Yeah, I'll send him new copies to the new address he gave me. And call me Tuesday between 8 and 10 more.
Okay, will do.
Okay.
Okay.
Thank you.
Oh, and so, yeah, this was an arraignment on the bench warrant at least, so I'll set a PR bond on
Thank
on
you.
the bench warrant.
Honored, you said May 14th, 8:15?
Correct.
Okay.
I'll get your staff the new address, Judge.
Okay, thank you very much, Ms. Holly.
Mhm.
Mr. Moore, you can go ahead and log out.
Okay.
Ms. Underwood, you need to speak to Mr. White Eagle.
No, Your Honor.
Okay. This is file 23-21423-FH People versus John F. Kennedy White Eagle. We are here today for a hearing on a violation of probation, and we are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. White Eagle this morning, Your Honor.
Okay, and where do we stand with Mr. White Eagle's case today?
Your Honor, Mr. White Eagle has new cases downstairs that are the genesis of this violation that Mr. Glazer represents him on. I would ask that this be adjourned for 2 to 3 weeks to allow perhaps whatever's going to happen down there to catch up with his matters up here, Your Honor.
All right, let's go with May 7th at 8:15.
What about a bail?
I'm sorry.
What about a bail or anything?
Your Honor, could I just have a brief breakout with Mr. White Eagle?
All right, we have Ms. Underwood and Mr. White Eagle back from breakout session. Ms. Underwood, anything further?
My apologies, Your Honor. Mr. White Eagle's bond downstairs, Your Honor, has been modified to 1,000 cash or surety, Your Honor. They were going to give him a PR, these are drug cases, Your Honor. They were going to give him a PR, but they wanted to see what was happening up here. I would ask that perhaps Mr. White Eagle be given a PR or a nominal bond with appropriate testing requirements, which I assume he's going to have from district court as well. Since this matter could take a little while, Your Honor. I don't believe Mr. White Eagle represents a threat to the community. And I don't believe he would not show up for court, Your Honor.
Well, I do have a concern in this case about the continued criminal activity and the what appears to be a difficult substance use issue that Mr. White Eagle has. He pled guilty in this case of possession of methamphetamine. He has a probation violation for possession of methamphetamine, and apparently now has new charges for possession of methamphetamine and possession of cocaine. And so I don't think under those circumstances that a PR bond or some kind of nominal bond is appropriate. I don't think it would sufficiently satisfy the court that there won't be any substance use going forward. I think that some kind of a bond is appropriate. And so I'm going to set it at $10,000 cash or surety with two times per week random drug testing.
Thank you, Your Honor.
Thank you.
If you are released, Mr. White Eagle, you need to contact Darren Coast in the pretrial services office within 24 hours of release.
Yes, sir.
And also contact your probation officer, Mr. White Eagle.
Yeah. He
Yes,
needs to
ma'am.
come see me.
Yes.
All right, so you're all set for today, Mr. White.
Thank you. Have a good day.
They were here, logged in, and then they disappeared. I sent her a chat message about that. Just we can do Paul Cherry. So are you Mr. Cherry?
Yes, I am.
All right. So this is file 22-20683-FH, People of State of Michigan versus Paul Edward Cherry. We are here today for a pretrial conference in this case and proceeding today by video conference. Ms. Underwood, do you want to place your appearance on the record?
Rhonda Underwood for Mr. Cherry this morning, Your Honor.
And where do we stand with Mr. Cherry's case today?
Your Honor, I'm sorry. Could I have a brief breakout with Mr. Cherry? I was not able to touch base with him.
Second. Okay, Mr. Grable, we do have Mr. Sepulveda here now. Are you going to need a breakout session with him?
I guess, yeah, I'll have a brief one, Your Honor, with the court's permission. That would be appreciated.
All right. All right, we have Mr. Cherry and Ms. Underwood back from the breakout session now. Ms. Underwood, how would you like to proceed?
Your Honor, we would ask the court to continue the not guilty plea and set this matter for perhaps a month or two down the road, Your Honor.
And what is the reason for that?
Mr. Perry, Mr. Cherry, I apologize, is involved in a Chapter 13 proceeding, Your Honor, that he feels may have some effect on the outcome of this, Your Honor, and on his fines and costs situation, or on his restitution situation.
All right, I'll set this out to June 18th at 8:15. So, Mr. Chair, your next day is June 5th. I'm sorry,
I'm sorry?
June 18th at 8:15.
June 18th?
Correct.
Thank you, Your Honor. And
Thank you, sir.
Mr. Perry, maybe that attorney should maybe you should retain that attorney for this case as well. Thank you.
Yep, thank you.
All right, you can go ahead and log out, Mr. Cherry. This is file 23-21604-FH, People of the State of Michigan versus Kevin Ryan Verlinde. We are here today for a hearing on a probation violation. We are proceeding today by video conference. Ms. Underwood, would you like to place your appearance on the record?
Rhonda Underwood for Mr. Verlinde in this matter, Your Honor.
Yes, Your Honor. My name is Underwood, and
Ms. Underwood, where do we stand with, well, I guess I should say first, Mr. Verlinde is not present today in the courtroom, and he has not logged into the Zoom session at any time this morning. This was set for 8:15, and it is now 9:33. So, Ms. Underwood, is there anything you'd like to say with respect to Mr. Verlinde at this point?
I have no knowledge as to his whereabouts, other than I received notice of another violation.
All right, there is a motion, an affidavit for bench warrant in the file signed by Mr. Coast. Mr. Verlinde had been released on a GPS tether And the allegation is that the GPS tether has been turned off for non-payment back on April 11th. And so at this point, I will issue another bench warrant for his failure to appear, and we will continue with the case once Mr. Verlinde has been taken into custody on those warrants.
Thank you.
Thank you, Judge.
I will set bond on the failure to appear warrant at $25,000 cash assured.
Thank you, Your Honor.
Okay, thank you. I think that is everything I had for you, Ms. Underwood, unless you had something that I missed.
Mr. Garcia, Your Honor.
He actually was Judge Anzalone's case because he is in drug court.
Thank you. Then I assume I'll see it down the hall. Thank you.
Okay, thanks.
Wait, doesn't she have Stover?
No, John Glazier is
Okay.
handling.
Okay.
I meet with Kelly and Judge Seegers. Good. We are looking for Mr. Glazier. I don't know anything about it.
Contacted him yesterday and said that he.
Hold on just a minute. I'm sorry.
We contacted him yesterday and I said that he would be handling it in place of.
Late Sandy was an adjournment. There's an email going around about an adjournment. Do you have a new date, Leo? Is it with Francis? Look. Okay. Kristen is the secretary of the drug court. All right, so Macomb County wasn't able to accommodate us today. Okay, and Francis was included in that, you said? Okay. All right, very good. Thank you, Leo. All right, bye. So Macomb County Jail, not accommodate our Zoom request. So
They were logged in since 8 o'clock this
seriously.
Yeah.
Okay.
They just, I think, disappeared while you were on the phone.
Do you? There's some confusion with Mr.
I mean, it doesn't matter now, so.
They want that to say it doesn't matter. Glacier said that they have to adjourn. Yeah. They don't like to do it. They love Glacier official.
The sheet is in our.
Okay, Mr. Malero, we're calling for Ms. Betzer right now.
Okay, thank you, Judge.
Hey, it's Kelly again. Could we get Alexis Betzer, please? All right. Thank you. Bye.
What's that? Okay, Mr. Milano, do you need to speak to Ms. Betzer?
Judge, why are we here? She has sentencing on May 15th.
She was arrested on a bench warrant.
Oh, all right. I'll need to speak to her then.
Okay, 1 second.
No. Thank you, Judge.
Well, okay, Mr. Mawad, you have Mr. Higgins here. Are you ready to go, or do you need to speak to him?
No, we're ready, Judge. My apologies. I have got a witness testifying in Livingston County on a murder case, and they wanted me to come on. So my apologies to everybody, and you and the court and the prosecutor.
Okay, no problem. Let me just find the file here. Okay, so this is file 24.
Yeah, okay, that's good.
24-21964-FC, People of the State of Michigan versus Matthew Virgil Higgins Jr. We are here today for a pretrial conference in this case, and we are proceeding today by video conference. First, going to have the attorneys place their appearance on the record, beginning with Ms. Arnold.
Allison Arnold for the people.
Your Honor, Elias Muan appearing on behalf of the defendant.
Okay, and Mr. Muad, where do we stand with Mr. Higgins' case today?
Judge, we have worked out a plea agreement where Mr. Higgins is going to plead guilty to a CSC second. It's going to be, I'm sorry, not guilty, no contest. The agreement with Ms. Arnold is to allow a 12-month sentence, and he would be on the Sex Registration Act for lifetime. And then whatever else I've forgotten, or Ms. Arnold, if she needs to confirm anything else, that'd be great.
I can put it on the record. I have it in front of me. He's
Okay.
going to plead no contest to count 3 only, which is criminal sexual conduct, 2nd degree. Both parties agree he shall be sentenced to 1 year incarceration in the Lenawee County Jail, followed by a probation term. The people will dismiss counts 1, 2, 4, 5, and 6, as well as the habitual offender 4th offense notice. This offense does require the defendant to register under the Michigan Sex Offenders Registration Act for life, and the other standard terms of our plea form apply.
And Judge, just for the record, as you know, we had a conference with the court. The guidelines are well over 12 months, but for reasons that were discussed, the plea has been worked out.
Okay. Mr. Higgins, would you raise your right hand? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty for perjury?
Yes, Your Honor.
And you are Matthew Virgil Higgins Jr.?
That's correct.
Mr. Higgins, you've heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead no contest today to count 3 criminal sexual conduct 2nd degree?
Yes, Your Honor.
Do you understand that the maximum possible penalty for that offense is up to 15 years in prison?
Yes, Your Honor.
Do you also understand that you will be required to register on the Michigan Sex Offender Registration Act for life?
Yes, Your Honor.
Are you satisfied with Mr. Mawad and the advice that he's given you?
Yes, Your Honor.
Neither the prosecutor, defendant, or anyone acting on the defendant's behalf has discussed a possible sentence with the court other than as we've discussed that on the record here today. Is that correct, Ms. Arnold?
It is, Your Honor.
Mr. Mawad?
Judge, no other promises or inducements.
Thank you.
If a guilty plea is accepted, Mr. Higgins, there will be no trial. That means you're giving up the rights that you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You do have the right to a speedy public trial by jury. You could ask for a non-jury trial, and if the prosecutor and the court agree, you could have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you were guilty, and you do not have to prove anything. You have the right to be present at your trial, to have the witnesses against you appear at your trial, to ask those witnesses questions. You have the right to have the court order any witnesses that you have for your defense to appear at your trial. You have the right to remain silent during your trial and not have that silence used against you. However, you also have the right to testify at your trial if you wanted to testify. Do you understand, Mr. Higgins, that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable if you were convicted at a trial?
Yes, Your Honor.
Do you also understand that any appeal from the conviction and sentence pursuant to your plea would be by application for leave to appeal and not by right?
Yes, Your Honor.
If you're not a citizen of the United States of America, conviction of a crime can result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about any of those rights?
No, Your Honor.
And do you understand that you're giving those rights up?
Yes, Your Honor.
How do you wish to plead to the charge that on or about July 14, 2021 through July 20, 2023 in Cambridge Township, Lenawee County, Michigan, that you did commit the offense of criminal sexual conduct, second degree?
I plead no contest, Your Honor.
Has anyone made any threats or promises to you to induce you to plead no contest to that charge?
No, Your Honor.
Do you understand that if I accept your plea, you'll be giving up any and all claims that your plea was given as a result of threats or promises that were not disclosed to the court on the record this morning, or that it was not your own choice to enter that plea?
Yes, Your Honor.
Is the prosecutor defense counsel aware of any promises, threats, or inducements other than the plea bargain to induce Mr. Higgins to plead guilty today?
Yes, you should.
No, Your Honor.
Mr. Higgins, other than as we've discussed it on the record here today, has your attorney promised you any particular sentence or estimated what your sentence would be?
Yes, Your Honor.
No, Matt, what other than what's been placed, has there been any other agreements as to what your sentence would be?
Oh, no, Your Honor. My apologies.
Okay. And is it your own choice to plead no contest today?
Yes, Your Honor.
All right. And Ms. Arnold, how are we establishing the factual basis?
Judge, I can put it on the record. If Mr. Muad's okay with that.
I'm fine. I'm fine with that. I think that's what we discussed, and I stipulate to your statement. Not a problem.
All right. This comes from Cambridge Police Department report number 1246 of 2023. And that report, between the victim initials MH, they received a report that she may have been sexually assaulted. There was a forensic interview conducted at the Lenawee County Child Advocacy Center. The victim was 11 at that time. She disclosed prior to her 11th birthday, during the charge dates, between the charge dates of July 14, 2021 to July 20th, 2023, at the defendant's residence at 9418 Gilbert Highway, which is in Cambridge Township, Lenawee County, state of Michigan, that the defendant engaged in sexual contact with her for the purpose of sexual gratification, in that he touched her vagina with his penis and his fingers at that location. With the disclosure being when she was 11, she was obviously under 13 years of age at that time, making out the factual basis for count 3.
All right, Mr. Mawad, do you agree that provides a sufficient factual basis?
I do, Judge. Thank you very much. Yes.
All right. Has the court complied with MCR 6.302 B, C, and D, Ms. Arnold?
Yes, Your Honor.
Mr. Mawat?
Yes, Your Honor.
All right. I will accept the plea then. It's been given understandably, voluntarily, and accurately. Mr. Higgins has had full knowledge of his rights and he has had competent counsel. The court has not made any agreement regarding the possibility of a plea or sentence in this case with prosecutor, defense attorney, defendant, or anyone acting in the interest of any of them other than as we've discussed it on the record here today. I will refer this matter to the probation department for a pre-sentence investigation and set sentencing for June 20th at 8:15 a.m.
Excuse me, Judge. Matt, I just want to let you know that puts us in a perfect time period for what we're doing here. So don't worry about it, okay?
Well, isn't it, if for the 12 months that you passed the,
Don't worry about all that. We're going to take care of that on the 20th. That'll all be calculated, okay? Don't worry about it. We'll explain it to you on a call. All right?
okay?
All right. Thank you, Judge. Thank you, Allison.
Mr. Higgins, someone from the probation department will be in touch with you to do a pre-sentence investigation interview. And so you are all set. You can let the officer that's with you know that you are done with court for today.
Okay.
Matt, we'll get a phone call with you.
All right.
Yeah.
Thanks, Judge.
Thank you.
Thank you.
Okay, Mr. Malero, are you ready to proceed with Ms. Betzer?
Yes, Judge. Did you hear me?
Yeah, give me just one second here. So this is files 24-22061-FH and 24-22062-FH, People versus Alexis Marie Betzer. We do have a sentencing pending in this case. However, Ms. Betzer was recently picked up on a warrant for alleged bond violations and pled guilty to that. So first, I guess, let me ask the attorney's place their appearance on the record, beginning with Mr. Bayonet.
Alex Bayonetto for the people.
Salvatore Malero on behalf of Alexis Betzer.
All right, and so Mr. Malero, Ms. Betzer was, I think it was last Friday, maybe, that she was arrested on warrant and pled not guilty and requested to have it set for today so that, you could speak to her, I guess. Do you know how she wants to proceed with this?
Your Honor, I would ask to adjourn this to, she has a sentencing date of May 15th. At that time, I would ask to address this matter at that time. I believe she's been approved for recovery court, which I think is probably in her best interest. So that would be our request.
Just so you're aware, we will have two bond violation issues to address at that time. There was a previous alleged bond violation for testing positive on February 16th. And I believe she pled guilty to that and has to have it addressed at the sentencing. And so this one will be added to that.
Understood, Judge.
Judge, I have down on 219, she pled not guilty to that contempt of court, that she was going to be screened for recovery court.
Yeah, I'm sorry. If I said she pled guilty, I meant to say she pled not guilty to that. So
Correct.
both of those are still pending. And just for clarity's sake, I think when we were on the record on Friday on the 11th, I had called the wrong case number. The contempts are in file 24-22061-FH. She does have a second file, but the contempts only apply in the 061 file. Okay, I think we're all set for today then, and we will be back for the sentencing hearing.
And Judge, what was that date again on the sentencing?
Sorry.
Judge, what was that sentencing date?
That is May 15th.
Thank you.
Okay, so Ms. Betzer, you can let the officer with you know that you are done with court for today.
Okay, thank you.
And you want to call?
Thank you, Judge.
And
We have Matthew Mayer for the judge. And Tessa Wood, please. All right, thank you. Bye.
okay, Mr. Malero, have you heard from Mr. Dunning?
Not recently, but I know he was looking at admitting himself to a hospital. He kind of goes back and forth. But let me see if I can find him, Judge, if you don't mind.
Okay. Yep.
No answer, Judge, on the phone call.
Okay, do you need to speak to Tessa Woolley?
Yeah, I do.
Okay, 1 second. Sir, you are Mr. May?
Yes, sir.
All right, your attorney is speaking with another client right now. As soon as he's ready, we'll call your case.
All right, thank you.
This is file 24-21981-FH, People of the State of Michigan versus Tessa Renee Woolley. We are here today for a hearing on alleged bond violations. We are proceeding today by video conference. First, can you have the attorneys place their appearance on the record, beginning with Mr. Bayanetto.
Alex Bayanetto for the people.
Yeah. Mr. Malero, if you said something I did not hear.
Salvatore Malero on behalf of Tessa Woolley.
Okay. And where do we stand with Ms. Woolley's case today, Mr. Malero?
Your Honor, looking at my notes, Ms. Woolley had entered a plea on the underlying charge. There was a contempt for testing that was adjourned out to the sentencing date. And I recall the court saying if she was clean, at that time, and I think that was April 3rd, if she stayed clean, you would dismiss that. But on Mr. Coase filed on March 31st, or I'm sorry, sometime after March 4th, a notice that she tested positive on March 31st and April 4th, which would be consistent, I think, with her continued use. But that was like, so if she had used prior to the April 3rd date when we entered the plea, I don't know if necessary to hold her to a contempt charge on that issue. So I'd ask that we enter a plea of not guilty and perhaps set that out. That said, Judge, I'd ask the court to consider testing Miss Woolley today, and if she is clean, comes back negative, to consider a personal recognizance bond with the testing requirement. She informs me that she had just obtained employment and is hopeful that job is still available if she were to be released today. So that would be our request. She has always appeared in court to my knowledge and has maintained regular contact with me. So I do not believe there's an issue with respect to her appearing in court. It's just a question of maintaining sobriety, at least that, from the allegations that have been made. That is our request.
All right, Mr. Bayanetto, anything you would like to say?
No, Your Honor, I will defer to the court's discretion in this matter.
Judge, she did test on 3/29. It was negative. On 3/31, she had meth in her system. On 4/4, she actually had more meth in her system than the 3/31 test. She has been showing up for testing. I mean, I wouldn't mind trying with her again. Maybe if we could throw in there testing with in which she be in which she's evaluated for programs.
All right. So Ms. Woolley's history in this case with respect to testing, either not testing or testing positive for methamphetamine use has not been good. And when I said that if she was clean from the day forward, I'm not sure I was aware that she had just used the day before. Usually those things are pitched to me as this person has now gotten themselves straight and around and has made an effort to clean up, not I used yesterday or the day of the hearing that we had. And so that I find troubling because it is a situation where I'm not told the entire truth of the situation when I make my decision. At this point, I will, if Mr. Coast is willing, give Ms. Woolley you one last opportunity. It will involve testing. If there's a missed test, if there's a positive test, this is it. This is absolutely it. And it will also control what I decide to do with sentencing. So you've got to understand there's a lot riding on you at this chance.
Yeah, I'm better. I can be better.
So I will allow at this point for the personal recognizance bond with the condition that Ms. Woolley do 2 times per week random drug testing. That you not commit any crimes while you are on release, that you not use any alcohol, marijuana, or illegal controlled substances. And that you participate in any referral for services, evaluation or services that Mr. Coast might make for you. So you will need to come over to the courthouse as soon as you're released to talk to Mr. Coast.
Okay. What do I do about my medical marijuana card? Do I turn it in? Because I know I'm very marijuana.
Bring that with you and show it to Mr. Coast and he'll discuss that with you.
Okay.
Thank you, Your Honor.
Yes, I'll see you in a little bit.
All right, Aaron. Thank you.
All right, and your sentencing date again is
May 22nd?
May 2nd at 8:15.
May 2nd or May 22nd? I couldn't hear. I'm sorry.
May 22nd.
Okay. Yes, sir.
All right, so you're done with court for today.
All right. Thank you.
Thank you, Judge.
File 25-2, Dunning.
You all set? Yes, sir. All right,
Sir, will you speak to Mr. May?
Judge, I think Mr. Dunning's on the phone. Just a second.
All right, then, Mr. Grable, are you ready to proceed with Mr. Sepulveda?
I am, Your Honor.
All right. This is file 23-21463-FC. People versus Ricardo Sepulveda. We are here today for a pretrial conference, a final pretrial conference in this case, ahead of the trial date set next week. We are proceeding today partially in person and partially by video conference. Ms. Hoffman, would you like to place your appearance on the record?
Yes, Your Honor. Benita Hoffman, Assistant Attorney General on behalf of the people.
Attorney Scott Grable appearing on behalf of Mr. Sepulveda, Your Honor, 53-310.
Okay, and so we have trials scheduled for next week. Have proposed jury instructions and voir dire questions been submitted?
Yes, Your Honor. I submitted the jury instructions a couple of weeks ago along with proposed voir dire questions. I did omit one voir dire question that I would like to add, and that pertains to the graphic nature of the photos. I forgot to ask about that and whether anyone would be bothered by that.
So just a question as to whether jurors would be bothered or have their decision impacted by the graphic nature of some photographs.
Right. I mean, there's some maggot photos and the body photos.
All right. Mr. Grable, any issue with a question along those lines?
I don't have a question, Your Honor, but there is a major issue I have to bring to the court's attention that just arose today, but I don't have a problem with that.
Okay. What is that issue then?
Your Honor, obviously, Mr. Amadeo has met with Mr. Sepulveda last week. Mr. Sepulveda today brought forth several issues concerning defenses that, frankly, I was unaware were even an issue in the case that he wanted pursued. And at this point, I'm remiss at this point to either ask the court for adjournment, or I may have a conflict in this case at this point because I'm concerned. I thought any unresolved issues were taken care of as far as some of the legal defenses or strategy that he has. Today, he brought forth at least 3 to 4 different things that frankly came as a surprise to me that he wanted to pursue. He was very respectful, so I'm not saying he was difficult. Obviously, he's incarcerated now. He's not going anywhere. I think, frankly, not at least pursuing these issues, which I was unaware of, would deny him his state and federal constitutional rights. I'm concerned about, frankly, a possible ineffective assistance of counsel claim. And I'm either going to ask the court for the adjournment, or I'm going to ask, probably, if the court denies that, I'm going to probably ask to file a motion to withdraw. And it's not something I want to do, but I'm not comfortable, frankly, of a case of this magnitude or any case proceeding forward. Mr. Amadeo, who I did talk to, obviously, before I came today, and I've met with Mr. Sepulveda myself. It's been a while, but I was unaware of any outstanding issues. Then obviously there's a new expert witness on this that the prosecutor that we obviously at least endorsed their credentials. We haven't had the opportunity to seek our own expert because that was filed a couple of weeks ago. It's not something I want to do. Obviously, Mr. Sepulveda isn't out on bond, so it's not like he's doing this as a stall tactic, in my opinion, because he's sitting in jail. But I don't feel comfortable proceeding forward with the several legal issues that Mr. Sepulveda brought to my attention. And if the court wants to query him, obviously, without getting involved on the case, I certainly am not opposed to it. But I told him, and he agrees, I don't think he feels comfortable proceeding forward until these issues, these legal issues, are flushed out. And I apologize, Your Honor. I was completely unaware of it before we came on the record this morning. I wasn't. So it came as a total surprise to me, and I apologize to the court as well as the Attorney General.
Ms. Hoffman?
Well, Your Honor, a couple of things come to mind. The first of which is that this case has been pending for a couple of years. And as we discussed the other day, this was not new evidence as far as the bug expert goes. And opposing counsel has stipulated to the qualifications and the science behind the entomologist who is going to be testifying. So I don't see where that is a problem and why they would necessarily need an expert witness of their own. And given that they haven't made the motion until just now, I think is problematic. The other issue is I don't know what the other 4 issues that he has to raise are or why they were not raised earlier. I will tell the court that these witnesses that we have called for the court One, they're getting very old. Many of them are retired Michigan State police officers. Second, I have witnesses who are not the most cooperative and who move about quite a bit. As the court knows from having to sign out-of-state witness subpoena documents, we've had to subpoena witnesses from the state of Ohio, which isn't necessarily an ordeal, but Texas and Texas and Louisiana also. The Texas witnesses in particular are germane to the case, and we've made flight arrangements. We're in the process of booking witnesses. So it is a horrible inconvenience. I've spent a considerable amount of time preparing in anticipation of this trial. I simply don't understand why these issues weren't raised earlier. I would like to know what the issues are as well.
All right, Mr. Grable, anything further you want to say at this point?
Your Honor, one of the wishes, I can at least disclose one of the issues. One of them would be obviously attorney-client privilege I can't disclose, but one of the issues was he felt the delay, and this came forth today, and I don't know what the legal precedent says on it, that the delay somehow violated his due process because the case is so old that he can't bring forth witnesses that he would have had available at an earlier date. And because it's been so long, it's prejudiced him. And this, frankly, I think he's saying it in good faith, but I was completely unaware of it till today. Another issue, which, I wasn't ready to address, was involving some type of expert witness. And at this point, I'm not even sure it's going to be applicable. But there were just several issues that, to be honest with you, I couldn't answer. I'm just obviously just uncomfortable at this point because I'm uncomfortable that he wants these issues resolved. I thought any unresolved issues were resolved, but obviously I found out later today, this morning, that they weren't resolved. So I'm in a very uncomfortable position. I do appreciate what Ms. Hoffman says, and I don't make light of any of the salient points that she made, that these witnesses are there and the age of the officers. And I don't minimize her concerns in any way, shape, or form. I think they all have salience to them. Obviously, the only thing I could say to Ms. Hoffman is obviously the magnitude of this case is I want to make sure the client knows that all the issues that he thinks are relevant are flushed out. I was unaware of. She knows he's not going anywhere. He's sitting in jail, so he certainly doesn't pose a risk to the public or a risk to the community. I think if he was bonded out, I think that might be a different analysis for the court, that this might be considered a stall tactic. But obviously him being locked up, obviously I don't think the court has that concern about safety or the reasons. I just don't feel comfortable proceeding forward. Whether if the court doesn't grant the adjournment, I probably would file a motion forthwith, probably to withdraw, because I'm looking at, frankly, ineffective assistance of counsel claim. And I'm not saying it has merit or not have merit. I don't even know, because I haven't researched these issues that he wanted, to be fair.
If I could, you're
the court and Ms. Hoffman, I do.
Thank you. With respect to the claims, first of all, I don't think you can legitimately claim ineffective assistance of counsel when the defendant just raises the issues at the last minute, and it appears to be an effort to stall trial. With respect to the delay and the violation of his due process rights, the defendant waived his right to a speedy trial. So in terms of the 180-day rule or anything like that, that's not applicable here. The second issue is the constitutional grounds with respect to the length of time that it took to bring the case forward. The defendant would have to present some sort of evidence to show that he's prejudiced in some way. There's an 18-month limitation typically, and at that point, the state has to prove that he is not harmed or prejudiced by the delay. Clearly, we were past 18 months when it took in terms of not charging, but proceeding with the case. But that really only comes into play once the individual has been charged. We didn't sit on our hands on this case. We didn't have a solid lead. We knew that there was some information that the Sepulvedas were involved or may be involved, but we didn't have any physical evidence. We didn't have any confessions, and they had been unable to locate the Sepulvedas to interview them. So I don't think that there's any wrongdoing or malfeasance on the part of the state. And then the other issue is that the the defense has had close to 2 years to bring this issue. I mean, I would have thought that a constitutional issue regarding speedy trial or any due process issue related to the delay in prosecution would have been raised way back then. But now they're just raising the issue literally 4 days, well, 5 days if you count the weekend, right before trial is supposed to start. Normally when opposing counsel asks to adjourn a trial, they have to show good cause, right? They have to establish that there's some good cause for granting the adjournment. And I think they also have to establish, I don't think just simply raising a new issue at the very end is sufficient. And I don't know the court rule off the top of my head, I'll be honest with you, but I believe it's 6325, is it? 6325, MCR 6325 pertaining to trials and adjournments. They have to establish good cause, and they haven't, I don't think, done that in this case in a way that is not something that could be considered trial strategy. So, you know, it just, I think it screams of unfairness from their standpoint. I think it's an effort to delay the proceedings, to make it harder to find witnesses, and perhaps for Mr. Sepulveda to access whatever contacts he has on the outside of the courthouse to contact those witnesses and potentially scare them off. This is a drug-related crime in which we believe that the victim was killed because of his involvement in the cartel, because Mr. Sepulveda didn't want to pay what he was supposed to do. And all of the witnesses who know firsthand or who are close to Mr. Sepulveda are absolutely terrified to come in and testify. So I'm concerned about the loss of our witnesses because of the passage of time and the inability to locate. There's no good reason why these issues weren't raised previously. Thank you.
Judge, the only thing I would say, I would ask Ms. Hoppins, in the last 2 years, does she have any influence that my client has done anything or tried to influence any of her witnesses? Since she mentioned that she's a concern, has that happened in the previous 2 years, that she can name one instance that she thinks there's been some type of witness tampering or intimidation? I guess I take umbrage to that because I'm not aware of anything during the pendency of the case that suggests that at all. So if the court thinks that's a consideration, I would ask her to make an offer of proof if there's something that's happened other than pure conjecture, at least on that facet. Believe me, I'm not happy about asking adjournment. I just don't think there's any merit to that particular aspect of it, respectfully.
Well, I would say first that this trial has been scheduled 2 times previously and adjourned 2 times previously. If I recall correctly, I believe that was at the request of defense counsel. With respect to the due process issue, this case obviously is old. It has been adjourned a number of times. Mr. Sepulveda has never asserted his speedy trial rights until today. This is the first time I have heard anything about this. In addition to that, the defense has consented to the numerous adjournments of pretrials in this case. And so I do not perceive there to be a speedy trial due process issue that has any merit at this point. With respect to the expert issue that you raised, Mr. Grable, we resolved that on Monday. The court did find that the expert was relevant. The expert had been previously disclosed to the defense, and the expert was listed on the people's witness list in accordance with the what is required in terms of timeliness. With respect to the other issues that there may be, you have not informed me of what those are. And so I have no way to analyze those to determine whether they constitute good cause or not. So I don't perceive there to be any reason at this point to adjourn the trial, and I would deny any request to do that. I would also like to address the other acts evidence that we discussed at a motion hearing on Monday. I have had time to review the notice as well as the objection in greater detail, and I am prepared to make a ruling on that at this point. So I think what I will do is go through each piece that was listed in the notice item by item and let you know my ruling on each item. I think that's the most logical way to do it. So the first item raised by the people was they want to introduce evidence that Mr. Sepulveda had been involved in dealing marijuana, cocaine, and heroin since his early 20s. This evidence, I don't think, does anything in particular to establish the res gestae, the motive, the identity of the victim, the knowledge or relationship between Mr. Sepulveda and the victim, or the intent. Therefore, I don't see a viable non-character purpose for this evidence. Even assuming that there is a valid non-character purpose for that evidence, I think it would be of limited probative value, as it only informs the jury of the length of time that Mr. Sepulveda had been involved in drug dealing. And I think that any probative value would be outweighed by the potential for prejudice of simply casting Mr. Sepulveda in the negative light of having been a drug dealer. So I would exclude that piece of evidence. Next piece is that Mr. Sepulveda had a group of people that used to help him transport drugs from various locations throughout the United States and bring them back to Toledo, including Joshua Sonkrant, Brian Churko, and Brahim Dahar. I think that this evidence does establish potential for opportunity for Mr. Sepulveda to come into contact with the victim. And I think it's necessary to contextualize some other evidence that is admissible and probative in this case, particularly the piece that Mr. Sepulveda had Ms. Lozano pay the courier. And I think this relates to Mr. Sepulveda's knowledge of the victim and potential motive. So I think there is a valid non-character purpose for that evidence. I also think that the probative value of that evidence with respect to establishing that Mr. Sepulveda had an opportunity to come into contact with the victim in the course of his dealings is high. It's also probative of the fact that Mr. Sepulveda and the victim knew each other, and probative of motive. I think that probative value is not outweighed by the potential for prejudice, and I would find that that piece of evidence is admissible. The next piece is that Mr. Sepulveda and his girlfriend, Laura Lozano, Mr. Sepulveda had his girlfriend, Laura Lozano, take money to pay the courier from the drug cartel after they received a call at their home that the drug courier knew where Mr. Sepulveda and Ms. Lozano was living. I think this evidence establishes that Mr. Sepulveda and the victim knew each other and had some kind of business or financial dealings related to drugs. In addition to knowledge of the victim, I think that this evidence can be used to establish motive. And I also think that the probative value of this evidence with respect to establishing Mr. Sepulveda and the victim knew each other is high. It's also highly probative of motive. Probative value of this evidence is not outweighed by the potential for prejudicial effect on the jury. And so I would find that that piece of evidence is admissible. The next piece of evidence is that Mr. Sepulveda was arrested in Indiana for trafficking in drugs. This piece of evidence, I don't think does anything particular to establish res gestae motive, knowledge, or relationship between Mr. Sepulveda and the victim. Therefore, I don't see it as having a valid non-character purpose. Assuming it did have a non-character purpose, I think it has limited probative value. It informs the jury only of the length, only informs the jury that he was arrested in another state for another incident. And I think that any probative value in that piece of evidence would be outweighed by the potential for prejudicial. Next piece of evidence is that Mr. Sepulveda had drug contacts in Toledo, Chicago, Phoenix, McAllen, Texas, and many of the witnesses had been with him during transactions related to drugs or when the drugs had been in Mr. Sepulveda's possession. I think this again establishes opportunity for Mr. Sepulveda to come into contact with the victim. It also, I think, contextualizes other evidence that is probative in this case, particularly as it relates to who the victim is, how they knew each other, and what the potential motive for the crime would be. Probative value of this evidence with respect to establishing those things is, I don't think it's outweighed by the potential for prejudicial impact. And I would find this evidence admissible. However, I would be concerned with the time frame with respect to this evidence. I don't know what the time frame is, but I would put some reasonable limitation on that in terms of temporal proximity to the alleged crime in this case. The next piece of evidence is that William Morgan, Misty Reynolds, and Michael Sepulveda will testify that Ricardo Sepulveda was violent when it came to handling problems related to his drug trafficking organization. Unless we are talking about specific instances, testimony that he generally uses violence to collect drug debts seems to be character evidence to me under 404A and not other acts evidence under 404B. It does not appear to fall within any of the exceptions to 404A. And it would appear to me that this evidence would be offered simply demonstrate a general propensity for violence and not bear any relation to a disputed fact in this particular case. So I would exclude that evidence. Next piece is that William Morgan testified that Ricardo Sepulveda tried to run over a man with his Jeep because he owed Ricardo money for drugs. Again, in this piece, it is unclear to me what, if any, relationship this incident has to the incident for which Mr. Sepulveda is being tried. Does not appear to me to establish any part of the crime, the res gestae, motive, intent, identity of the victim, knowledge of the victim, relationship between Mr. Sepulveda and the victim, or intent. It appears to me to be simply establishing the fact that he has acted violently in the past for the sake of showing that he was violent on this occasion. And so I don't think it's admissible other than that. The next piece is that William Morgan will testify that Ricardo and Michael severely beat up a man in a bar over a small drug debt. And I would offer the same analysis that I did on previous piece of evidence, rationale for excluding this piece of evidence. I don't see how it bears any relationship to a fact that's at issue in this case, and I don't see it as establishing the res gestae, motive, identity of the victim, knowledge of the relationship between Ricardo Sepulveda and the victim, or intent. It appears to me to simply establish that he has been violent in the past and therefore he was violent on this occasion. The next piece is that Mr. Sepulveda threatened and battered Misty Reynolds over revealing information about his drug dealing and his possible involvement in the homicide while they were living together out of state. I think this is a piece of information that can be used to establish consciousness of guilt. The evidence is highly probative of that. The probative value is not outweighed by any potential prejudice. And so I would find that this piece of evidence is admissible. The next piece is that Mr. Sepulveda fled, that Ricardo and Michael Sepulveda fled to Florida after the murder. I do believe this is part of the res gestae of the alleged crime. The acts, conduct, and demeanor of a person charged with a crime at the time of, or shortly after, shortly before or after the offense is claimed to have been committed, may be shown as part of the res gestae of the offense, and I think it fits within that. The next piece is that Mr. Sepulveda sold the van that was used in the crime to Joshua Sonkrant. I also think this is part of the res gestae of the alleged crime. Again, the acts, conduct, demeanor of a person charged with a crime at the time of or shortly before or after a crime may be part of the res gestae. I think it falls within that. And I think this evidence is also relevant to whether or not Mr. Sepulveda committed the offense. Flight obviously can be used to show consciousness of guilt, or attempts to cover up the crime can be used to show consciousness of guilt. And I think that it is admissible under that basis. Last item is in the notice was that the people also intend to present evidence that the defendant resorts to violence when necessary to collect a drug debt or when necessary to prevent disclosure of his involvement in drug dealing and the homicide, to show knowledge of the homicide, identity of the perpetrator, victim, and motive for committing the crime. Again, unless we're talking about specific acts, testimony that he generally uses violence to collect drug debts seem to be character evidence to me under 404A and not other acts evidence under 404B. It does not appear to me to fall under any of the exceptions within 404A, and it would appear to me that this evidence, the only rational basis for this evidence would be a general propensity for violence, which would not be appropriate, and therefore that evidence is not. I think I've covered everything in the 404B notice.
Just need clarification on one point. One of the pieces of evidence that we intended to offer was testimony from Misty Reynolds, in which she claims that he threatened to kill her after he found out that she was talking about his involvement in the crime. Would that be admissible or not under 404B? And the theory we would offer it for is knowledge, consciousness of guilt.
Yeah, I would treat that the same as I had covered. I think there was a statement that said that Mr. Sepulveda threatened and battered Misty Reynolds over revealing information. I would treat that the same way as I did that.
Thank you, Your Honor. I'm sorry.
So that I would find as admissible.
I do have some questions about the trial, if the court's ready for that. Okay. The first and foremost is with respect to projecting the exhibits, is there a way to connect the computer to the screen over there?
Yes, there is on the floor in front of your table an HDMI port.
Okay.
And so as long as your computer can plug into that HDMI port in the floor, it will project onto the television screen here in the courtroom. Okay. I do recommend that if you have time, you come in maybe before now. Do you have your computer with you? Sometime before now in the trial to plug it in and make sure everything works smoothly. Okay. It can be a little finicky depending upon what program you're running. Sometimes it works great. Other times I've had prosecutors run into glitches, and I just like to try to work those out to the extent we can. Or the
Okay.
jury's waiting on us.
Would it be okay if I came in on Monday to check it out?
Would depend on the time on Monday. If you could do that between noon and 1:30, that would be
Yeah, I could
ideal.
do that.
And I'll make sure that I stay here, so he's here to let you into the court.
Thank you. So then would it be acceptable to put all of the exhibits on a thumb drive and provide it to the court and opposing counsel? They have all the exhibits, but they haven't seen the ones that are specifically delineated for trial yet. Is that going to be acceptable, or do you want physical copies?
I think I'm comfortable with a thumb drive, just with the understanding that the actual projection of it is going to have to come.
Understood. The next question that I have a few witnesses on my witness list who, after further interviewing, I have determined are going to be cumulative in nature, that they don't have anything specific to add. And that's Detective Sergeant Slick from Michigan State Police. His partner, Detective Sergeant Hugh Welch, will be here. So I don't feel that Detective Sergeant Slick is necessary. Detective Sergeant Barrett, his testimony is also cumulative. Detective Sergeant Krebs was in training at the time, and the officers training her were available to testify, so I don't feel as though she's necessary. And then Detective Sergeant Kyle Hoskins is the person that did the hair analysis in this case, and by way of offer of proof, all she can tell me is that she did a microscopic analysis and that she could identify that the hair came from a Caucasian male, which includes a Caucasian, excuse me, not a male, a Caucasian, which could include a Hispanic or a mixed race person. And she felt like she would be more, that her testimony would not be helpful. I'm inclined to agree with her, given that she can't be more specific than that. I understood her report to say something different, but when I spoke to her, she was much more specific. And then the final one is Fred House. He's 77 years old. He did the urology analysis, and after speaking further with people, the alcohol that would have been in the victim's blood may very well have been the product of decomposition. And so I don't feel as though I need him. I had reached out to opposing counsel about that. I've not heard back. That was to Mr. Amadeo, if I pronounced that correctly.
That's correct.
Does opposing counsel have any objection to
No.
that?
No, I don't.
Okay.
So having said that, Ms. Hoffman, if you could send an email to our research attorneys here in the green with the names of the people who will be called.
Okay.
We just need to update our jury instruction on that point.
The next question that I wanted to ask about was the stipulation regarding the bug evidence and whether or not that include Heather Milch. Heather Milch was the individual who collected the vial and took it to the bug expert. It's just simply a chain. Witness, do you want me to produce her, or are we comfortable excluding her? I have to bring her in from the FBI from Virginia.
You can exclude her.
So we have a stip to chain as to the bugs?
Yes.
Okay. And the final one, I think I will probably get some resistance on. That is a request to add two witnesses, Tommy Thomas and Joshua Sunkron. They're both discussed. The scope of their testimony is heavily discussed in all the discovery. They were left off of my witness list. I would like to add those two.
What's the offer of proof? What's their, I don't have it in front of me.
Yeah, so Tommy Thomas was at Laura Lozano's house And he received information. He is a person that contacted an informant, contacted one of the police officers. And that's sort of the scope of Tommy Thomas. And then the next one is Josh Sankrant, and Josh Sankrant was the person who purchased the van and who got busted in the van.
Yeah, well, I'll be objecting to that. This is obviously before 30 days on trial, so I'll be objecting to both of those under the court rules.
Is there a reason, Ms. Hoffman, they were left off your witness list until now, or what?
Your Honor, it was an oversight on my part. As I stand here today, I would simply reserve the right to use those as rebuttal witnesses should it become necessary.
Well, obviously, oversight is not good cause, and obviously rebuttal, if there are appropriate rebuttal witnesses, I guess the court can rule on that during trial.
I would obviously wait to address that issue then until it arises.
Thank you. I believe I can get what I need through other sources and just use them as rebuttal.
Okay. Anything else from your end, Ms. Hoffman?
No, Your Honor.
All right. Mr. Grable, any questions or issues further to raise from the defense?
Not at this time, Your Honor. Thank you.
All right. All right. I think that's everything then for today. So Mr. Sepulveda, you can let the officer that's with you there in Washtenaw County know that you are done with work for today.
Yes, Your Honor.
Mr. Grable, I'm open to conversation until the 21st, if that's what you
Okay,
wish.
I appreciate that, Ms. Hoffman. And I think, I know that let me just ask, and I don't want to take up the court's time. What's your direct number? I know Mr. Amadeo is home sick and I don't have it. I apologize.
Hey, what, don't say it right now.
Okay,
Don't say it right.
okay, pardon me then. There's other people. I'm sorry.